We now present For the Record.
Just ahead, breaking down a week of turbulence as the Darrell Brooks trial got underway.
That's the fourth interruption.
The judge has the patience of Job.
And now that a lawsuit challenging Biden's student loan forgiveness program has been tossed, what comes next?
We shouldn't want a single person to be able to decide to spend $1 trillion.
Plus,
it seems like the state would much rather have had us go out of business.
Welcome to For the Record. I'm Naomi Coles. A conservative legal firm in Wisconsin is trying to sue President Biden to stop the rollout of a massive student loan forgiveness program. The core argument that the president is overreaching his legal powers. But on Thursday, this hit a snag with a federal judge tossing the lawsuit. I'm joined now by the president of the Wisconsin Institute for Law and Liberty, Rick Esenberg. Good morning.
Good morning.
So the lawsuit has now been tossed by a federal judge. What comes next?
Well, this was not a surprise. The big challenge here with respect to the president's unilateral decision to spend $1 trillion and erase a portion of student loan debt is finding a plaintiff who has standing, and that's a very technical concept in federal court. We've made a particular argument that we think is appropriate in a case like this, but we understand that it's probably an argument which the appellate courts and ultimately the Supreme Court are going to be more receptive to, because we are asking that the law be extended. So it's not surprising to us that the district court dismissed the case. We will now take the case up on appeal to the Seventh Circuit. They will weigh in, and then depending upon what happens, it may be that we'll request to have this reviewed in the United States Supreme Court.
I want to get a little bit into what you just mentioned, standing, or does your client have the, is able to bring this lawsuit? I'm going to read from this judge's decision in tossing your lawsuit. The Supreme Court has repeatedly held, quote, that the payment of taxes is generally not enough to establish standing to challenge an action taken by the federal government, end quote. So your plaintiff, it's a group of taxpayers in Brown County, and the chief complaint is will this, this will increase their tax burden too much. So how do you plan to get around this legal barrier, even in an appellate court?
Well, there are a number of cases. The Supreme Court has held in the past that there are certain circumstances when the challenge is to an exercise of the taxing power itself. That is, it's not simply a taxpayer complaining that he or she doesn't like what the government does, but that the taxing power has been exercised inappropriately. In this case, the president of the United States has essentially added $1 trillion to the national debt by foregoing the collection of these student loans. He's done it unilaterally without congressional authorization. That in this instance, an exception should be made, and taxpayers' standing should be permitted to challenge this, because whether you're on the left or whether you're on the right, whether you love student loan forgiveness or you think it's an awful thing, we shouldn't want a single person to be able to decide to spend $1 trillion. That's not the way our system works. It's Congress that's supposed to authorize that with, either a signature or veto by the president and an override. And so I find it amusing that people who are so concerned now about threats to our democracy are not concerned about a president taking unilateral action like this. And our view is that the law ought to permit someone to come into court and challenge this.
Yours is one of several lawsuits, but there's something that sets yours apart from others around the country, and that's a reference to a racial component. Allow me to read from your complaint, quote, student debt relief plan is motivated by a desire to, quote, advance racial equity and narrow the racial wealth gap. To achieve equity, the plan, according to the White House, is more likely to help students, black borrowers, and other borrowers of color, end quote, and that is complaint. So what exactly is the concern with this federal plan that benefits, in your words, black people more than others?
Certainly, the problem is not whether a plan benefits black people more than others. It's whether the government chooses to enact the plan because it has a racial impact. The government's decision making should be race neutral. This is a very, very bad history. You know, back in the 50s and the 60s, when explicit racial preferences were finally outlawed in Brown versus Board of Education and other cases, some southern states decided to enact laws that did not have explicit racial classifications, but that they knew would benefit white people more than black people. And the Supreme Court called them on that because they were taking race into account in their decision making. And that's what we think the problem is here.
But to your point, pointing to past decisions, pointing back to the 1950s, 1960s, this policy itself is race neutral in terms of who can apply. So what I'm saying there is there's nothing on the application that makes someone of color more likely to get a student loan than others. The government was simply pointing out it could help reduce a racial gap. So how does that compare? I mean, it doesn't seem like an apples to apples comparison there.
Oh, it certainly is, because these programs in the past that were enacted in southern states, they didn't have explicit racial classifications either. It was all public schools are going to be closed and you can have a voucher. It was, all public swimming pools are going to be closed. But they knew and enacted the program because they thought that the result of that would be segregation, and it would be swimming pools for white people, private schools for white people, and not for black people, or at the very least, very inferior pools. And so, the problem here is the racial motivation. The argument that we're making, and certainly free to disagree if you wish, is that when government acts, it should never take race into account. Whether it thinks it's helping, minorities or it's helping white people, it simply shouldn't take race into account. That is a consideration that the government needs to put off the table when it's making its decisions.
Do you foresee consolidating with any of the other lawsuits also challenging this program around the country?
It's always possible. It's possible that the court will decide at some point to consolidate the cases, but I'm not aware of any plans that anyone who's brought them has to do that.
All right. Rick, thank you so much for your time. I appreciate it.
Thank you.
All right. Up next, an astonishing first week in the jury trial of the man accused of killing 6 and injuring dozens at last year's Waukesha Christmas parade.